Guys, I hope you're now awake and ready for this amazing webinar. If not, these amazing announcements will get you there. So don't worry. Well, welcome everyone. Welcome to our webinar today. This is BPM RIA, Broward Palm Beach, Miami Real Estate Investors Association, your only local chapter here in South Florida that is partnered with the National Real Estate Investors Association. That I will tell you guys in just a second. They are going to be here in South Florida this week. So I'll tell you guys in just a moment, but welcome to our webinar. My name's Alexa, Operations Manager at the BPM RIA office. We have our Rapid Probate to Clear Titles webinar today with Fred, probate attorney, and Harry, one of our local real estate investing mentors here at BPM RIA. So guys, we do have a raffle today. You want to win the 1-year membership to BPM RIA. All you have to do is text the word membership to our event line 954-800-6961. And I will go ahead and throw that in the chat box for you guys. I'll be throwing a lot of helpful things in the chat box. So just take a look at the chat. If you'd like to opt in the raffle, it'll be noted in there. Or go ahead and take a quick picture so you can win a 1-year membership to BPM RIA. Awesome. And guys, we have a lot going on. So go ahead and check out the website later. Everything will be posted there. I'm going to be continuously posting events to our website. So just keep checking it. Keep looking out for these amazing events. They will be there for you to register as soon as possible. Just a lot of great things coming up. So take note. We have a webinar tomorrow, Wholesaling Investing for Newbies. Anish is going to be teaching this webinar. We will have a raffle, so hope to see you guys again tomorrow morning. This week, like I briefly mentioned in the very beginning, National RIA is coming to South Florida. They will be having a winter conference Thursday to Saturday, February 23rd to 25th. That is this week, guys. So if you have any questions about this, please reply to my email that I will be sending each and every one of you at the end of today's webinar. I will send you guys the proper link for this, all the details, and somebody to reach out to if you have any questions. So we will be there. Anish, Harry, and I, and a lot of great members from BPM RIA will be there. So we hope to see you there. If this winter conference suits you, I'll send you all the information so you can see what we're talking about, what they are talking about. Anish is a panelist at this event. We are not hosting the event, but we would love to show our representation and show National RIA what we're about here in the Tri-County area. So.
Yeah, I'm just going to add to that. So there's going to be the 2.5 days. There's going to be a lot of really good stuff. John Bowens from Equity Trust is going to be there too. So I know we always get a lot of questions about self-directed IRAs, Roths, all the above. So they're going to be doing a class. There's a ton of good stuff on it. So usually this is the cruise because of the COVID situation. They decided to come down to Florida and not do a cruise this year. Next year, they will do a cruise, I believe. So that should be pretty fun. Some of you guys came to the Saturday event with Harry and I, the WIN event. So that's what we're calling it, Wholesale Investing for Newbies. It's going to be pretty awesome. We're going to show you some of the big deals on it. These are free, guys. And actually, for one of you guys, like today, I'm actually paying you to watch us, meaning for a free membership too. Scott, Jelnick, Slow Flips to Freedom is pretty awesome. I got to recently see him in Phoenix at my mastermind, and without a doubt, it's a whole different look on how to do flips and owning things free and clear, something that I've never seen before and have anyone else actually teach. So I figured we'll get him to sneak in also. And then, go ahead. I'm sorry.
I'm really excited to see Scott's presentation as well and what he's doing. I know it's different because I've seen many different speakers these past couple years. So, and I know you guys are going to like him too because you're looking for something different and new. So hope to see you at our monthly meeting on March 1st. And then right around the corner, again, another WIN workshop in person. I do have the location locked in, but it is not posted yet. So you guys must look out for this next opportunity, in-person workshop. Just little tidbit, it'll most likely be in Miami-Dade County. So look out for this, my down south people, March 11th. Just go ahead and mark your calendar right now if you are in town this weekend and you want to learn wholesaling from Anish and probably get an awesome raffle again. So look out for this one. And then tax planning strategies. We need this, guys. We love Jose. We need him to keep building our brains on how to strategize and get the most out of our business using tax planning. So go ahead and check out the website, bpmria.com. Link is in the chat. And as you guys know, my favorite way to keep up with the events is via text. So easy. Text BPMREIA, all one word, no spaces. Leave the little markies out. Text it to our event line, 954-800-6961. So you can get a text update for the event with the registration to your phone. So easy. And let me know if you guys have questions about that, but it's in the chat box. Quick start 2-day boot camp. This is coming up April 15th and 16th, right around the corner, you guys. If you have any questions, let's go ahead and address it now, or go ahead and get your tickets. People are buying tickets already for our April quick start. So this is online. It is Zoom. It is cameras on, microphones on. It is very interactive, although it is online. You will have an itinerary so you guys know what's going down, what time, what speaker is speaking at what time, all the topics of discussion, 4 incredible guest speakers. The entire training is led by Anish. You have a booklet to keep for life, and it is a money back guarantee. So as you see down below, member and non-member pricing, we're getting into all these amazing topics that you see on the screen. And I went ahead and linked it in the chat for you guys, so you can go ahead and look at all the different topics and speakers that will be at the training, and look for yourself, do your own research. And thank you guys so much for responding to the poll, because it looks like a lot of you are interested. Most of you are interested, which is amazing. The majority of you have attended, but most of you are interested. So let me help you get your questions answered and get you signed up for this 2-day training. Let's make it happen. And I look forward to seeing you guys there. So thank you guys. You guys are awesome. Thank you for responding to the poll. You guys are the best. Let's do this thing. Memberships, as you guys know, the members do get the special pricings. They get in free for the in-person networking meetings. Their guests come in for half price for the networking meetings. They get the amazing benefit package from the National RIA, discounts to Home Depot, Office Depot Business, Avis Budget, Equity Trust, insurance, so many great vendors. If you have any questions about those vendors or what else is included in the membership, I'm more than happy to answer those questions for you. Go ahead and link it. I linked it in the chat for you, so you can go ahead and look for yourself. And let me know if you have any questions about the memberships.
Yeah, I just want to add also, I know National RIA's event that's coming up, they have member pricing and non-member. I think the member pricing's $199. Am I right, Alexa?
I believe so.
Yeah, and then the non-members $299. So it's a quick way if you become a member to save $100, guys. So that's what I tell people.
Absolutely. And I will make sure you guys all have my contact information. So if for any reason your membership, anything needs updated, I'm more than happy to help with that. So let me know ahead of time, guys, so I can help you guys out with that. And as you know, we do offer one-on-one coaching and mentoring here at BPM RIA. This is my direct line down below, but I do have the easiest way for you to get a call with me right now. Go ahead and go to the website, go to bpmreia.com and book a discovery call with me. If you'd like more details of what's included in our mentoring coaching program, pricing, all the tools that we give our students to set them up for complete success to do deals right now, I can more than happy to share all of that with you in a discovery call, and also help schedule a free consultation with a mentor so you can get all your questions answered. We do put up 100% of the money for our students' deals and split the profit 50-50. So if you have any questions about this, go ahead and go to the website and book a discovery call with me. My email is in the chat for you guys right now. So go ahead and reach out. I'll look for your discovery calls. so I can help answer all your questions about our mentoring and coaching program or the boot camps that we offer. So last but not least, and thank you guys so much for responding to all of our polls. We appreciate it. Last but not least, thank you guys for being in this webinar today. We appreciate your attention, your participation, your questions, everything. Thank you so much to our corporate vendors, the National RIA, our speakers for Fred, Harry, and Nish. Thank you guys for taking your time today. I am super excited to hear all the amazing things that you guys have been working on, but I'll go ahead. I know Nish probably has some words for you guys, so I'm gonna hop off. But I'm really excited for today's webinar. So
Awesome. Thank you, Alexa. And
Thank
again,
you, Alexa.
that's the brains behind the office here at BPM RIA. I do see some new faces virtually, meaning names on participants. So my name is Anish Dave. I am president of BPM RIA. We were BRIA, the Broward Real Estate Investors Association, and we did change our name last year to BPM RIA, which stands for Broward Palm Beach Miami-Dade RIA. As a longtime investor for 20 plus years, I've done a lot of different kind of deals, and some of the most profitable deals have been probate, right? Without being glum, who would have thought death was so profitable, at least for the living, right? So again, without a doubt, when I first looked at probate deals, I didn't understand it. I said, oh, it's too hard. There's lawyers involved. I got to learn all this other good stuff. And I was like, yeah, I'm going to pass on that. Man, was I a fool, meaning I passed on a lot of money. And as soon as I started learning the probate process, and I realized it was starting to become a win-win for the heirs, right? For us, for the neighborhoods. It really started changing my life. And what we've seen on the investment side, our numbers have been through the roof. And it's been a lot of probates on that portion. So what I did also on this webinar, I have added also Harry Diamond, in case you guys don't know who he is. He's been a mentor for a few years. He's been part of our organization for at least 10 plus years, I believe. And, he's actually
lifetime student.
Lifetime
student.
and so and you guys have seen him at the meetings. You've probably seen him on some of the webinars. And, when, Harry and I were speaking about it, and we get a lot of calls about probate, he goes, I got the perfect guy for you. So this is where, we were very fortunate to get Fred on board. He's going to speak a little fast because he's a Northern guy like myself. He's a New Yorker. So no holds bar, whatever comes out of his mouth, it's legal. No, he's an attorney. So what I'm going to do is, Harry, if you want to introduce a couple things about Fred, how you met him and what you've done with him on our probate side, that'd be great.
Sure. As a matter of fact, over the years, I've maybe done 5 or 6 probates with various attorneys. But in my continuous research to help homeowners, I kept seeing this name Fred pop up. Fred Hochstein kept popping up. And then when I researched one of his deals, it was probably about November of last year. The start of the process was on Monday, and the judge signed the order on a Friday. And I'm like, I immediately got on the phone. I'm like, how did you do that? And he goes, well, that's my secret. But the average is about 2 to 3 weeks. I think that was probably his fastest one, was maybe 5 days. But he was very easy to work with, to the point where he told me what documents that were needed exactly, so I could save time on my side. And I put 5 probate deals to him already just in January into early February. So we got another one that should be due, coming, judge signed order today or tomorrow or something this week. And Fred is so easy to work with. I even brought one of our students down to Fred's office and met with him, and we just actually love Fred. Welcome to the team. So he's going to take over from here, and he'll tell you what we need to do. And I don't want to take up his time. So if I can pass it along, show him.
Thank you.
And give it to Fred. Welcome, Fred Hochstein.
So again, my name is Fred Hochstein. I'm an attorney with the law firm of Hoxtie and Harrison Jolly. Harrison Jolly happens to be my wife, so we are one of those law firms that have a husband and wife team working on it. My firm does probate, guardianship, estate planning, and real estate. Probate, of course, we're going to talk about. Guardianship is a situation where you have somebody who is disabled and is unable to manage their own affairs. It could be a child, it could be an elderly person, it could be somebody who's in an accident. Estate planning, of course, is doing wills and trusts and all those things that if your clients had done beforehand would have made this a whole lot easier. And finally, real estate, we do closings. We are title attorneys. We are part of the Old Republic title company team, and we can do closings for you as well. Today, the topic that I want to talk about is probate and how it can be done quickly enough to save your deals, to make your deals worthwhile to you, both in terms of cost and in terms of time. Now, for those of you who don't know, probate is a system whereby the court supervises the distribution of assets. They take into account the heirs if there's no will, the beneficiaries if there is a will. They take into account creditors who might be owed money by the person who died. And when we talk about creditors, it could be a credit card, it could be credit card debt, it could be hospital debt, it could be anything where there is the possibility of somebody filing a claim. Probate is not a bad thing. I mean, it, like bankruptcy court, it makes sure that the distribution is done in an orderly and fair manner. So there's no real problem with it. But in terms of what you all are doing, the problem with it is it takes time and it costs too much money. As far as too much money, typically probate costs 3% of the value of the estate. So for every $300,000 home that you might be purchasing, you're talking about $10,000 in attorney's fees and costs. And I know this because there's an actual statute that says reasonable attorney's fees are 3% of the value of the estate. And that's what everybody is charging you. On the other hand, as far as time is concerned, a typical probate cannot be completed for at least 4 months. And I know this because there is a creditors period that says creditors have 3 months to file claims. So you can't close down the estate until the 3-month creditor period is over with. And obviously, for you to hold on to properties that long is going to eat into your profits or completely cause the deal to fall through. So we need to have a system whereby we can get the properties out of probate fast enough to make it worthwhile to do things. Now, when we have property in the name of an individual, there are certain things that you need to know about. First of all, if property is owned by husbands and wives together, it is automatically survivorship. That means if husband and wife own a property and the husband dies, the wife owns it, or if the wife dies, the husband owns it. In this situation, we do not need to do probate. The surviving spouse is perfectly able to go ahead, sell the property, sign the documents that are needed. No probate is necessary. Now, there are two ways where probate will be necessary when the second one dies. It's between the two of them, there's no probate, but when the second one dies, you're going to need to do probate. However, if they had been sophisticated enough to get to an attorney ahead of time, there are ways to avoid probate. And this is one of the things that attorneys who do wills, one of his responsibilities is to the family unit, to make sure that the family unit pays as little as possible. So there are some techniques you need to look out for that will avoid probate completely. And the first one is called what is commonly called a ladybird deed. A Lady Bird deed named after Lady Bird Johnson, as a matter of fact, because President Johnson had all his property in this technique. A Lady Bird deed says that the person who owns the property owns it for the rest of his life, and immediately upon his death, it transfers to whoever he says it can be transferred to. This could be family members, it could be non-family members. It is a simple quitclaim deed that can be done. There are two kinds of quitclaim deeds, but generally everybody's using one particular one now. And if you have that deed, then you don't have to go through probate. If you need somebody to look at the deed, you are welcome to contact me as a service to my clients. I will look up deeds and explain to them what the situation is and what they have to do. But in that particular case, you'll be able to close immediately. The second technique, and one that's very much more sophisticated, is what is commonly referred to as a living trust. A living trust is a contract between the person who owns the property and a trustee, in this case himself. It's a legal fiction, but it's himself, to hold on to the property outside the person's actual name. And upon his death, there is a trustee who can transfer the property without going through probate court. Usually there's a document involved, which could be anywhere from 10 to 25 pages, depending on whether it's an attorney who is, on the wordy side. But this particular, this particular technique avoids probate court. Normally, a snapshot is taken upon a person's death, and in the event that he owns anything in his name, that's what has to go through probate. Now, in a trust situation, it's no longer in his name. It's been put into the trust. It is out of his name, and therefore no probate has to be done. And a person is able to, and the person who's been named in the trust can go ahead and transfer the property as any owner would be able to do. What they do with the money afterwards is not your concern, not my concern. They will do it with whatever they want, but it is a method of avoiding probate as well. Now, we, again, as service to my clients, I will look at the documents and again, say, this is what you have to do to close, even if I'm not going to do a probate and get involved. So keep that in mind. Now, there are some things about probate that you need to know. One is that there are different categories of probate. One category is whether there is a will or there is no will. When there is a will, it's called testate, and when there's no will, it's called intestate. And this is, again, very important. If it's intestate, then somebody's got to determine who the heirs are. Usually you follow the family tree, and the family tree goes children, grandchildren, parents, grandparents, sisters, brothers, nieces, nephews, and then continuing on if there is none of any of these categories. If there is a will, then you follow what's in the will, and that's what the judge uses to follow the heirs of who's entitled to receiving from the estate. In Dade and Broward counties, the person who is getting it is going to have to fill out an affidavit of heirs telling the court who is entitled to the property if there's no will to tell the judge. So it's a simple form in which you say who the spouse was, who the children were, who the parents were, and then you sign it under penalties of perjury and we submit it to the court. So there's intestate and there's testate. The other classifications is whether the estate is a full administration or a summary administration. A full administration, well, let's do it the other way around. A summary administration is any estate that's worth less than $75,000 or that the person has been deceased for more than 2 years. If this is the case, no matter what kind of property you have, you can transfer the property, not in the four to 6 months that normally it takes, but in the couple of weeks that Harry was talking about. Because at this point, creditors are barred because there's a 2-year statute of limitations. And if creditors aren't going to get anything, then we don't have to go through publication and all those things that delay the estate process. If it's more than 75 or less than 2 years, then we have to do the full administration, including publishing in the newspaper and giving the creditors their 3 months. Excuse me. So these are some of the considerations that we have to consider, that you need to consider when you are meeting with your clients to figure out what the situation is. Now, we're going to talk about at the end properties that you should probably avoid. But keep in mind that when a person dies, all of his relatives within a category are entitled. So if a person had 5 children, all 5 children are actually involved, even if they don't know where one of the children are, even if one of the children have died. So you've got to consider all these different categories of possibilities of probate. We're going to talk again about how you can help me, but the way you can help in terms of doing this is knowing all the information about all of these heirs ahead of time so that we don't have to start searching and delaying probate. So I haven't been following who's been texting questions, but let's stop now if anybody has questions about the probate process, and then we'll move on to how we're going to shorten all of our probate so that it's economical for you all to buy these properties. Harry?
Okay, Fred, one of the questions we have is, does a property have to go through probate if 6 siblings are on the deed and 2 are demised?
The answer is, this is one of those properties that are going to cause you a problem, and you may have to really consider whether you want to go ahead with the deal. If 6 people are on the deed, you have to account for all 6 people. Remember, real estate titles are chains. They go link to link to link to link. Usually the link is the warranty deed that you get. But in probate, the link is the court order or the personal representative's distributive deed, distributive certificate transferring the property. If 6 people are on the deed, you need to account for all 6. Now, if one of those people have died, the next question is, do they have any children? If they have children, then those children are going to stand in the shoes of the one who died. So if there are 2 children, there are 2 shares, 3 children, 3 shares, and they are now the heirs of that property. So you could have 5 single shares, and then the 6th one who died, you could have 2 half shares for each to make up 6. The reason why you have to consider whether you want to continue with this property is you're going to need probate for the ones who died. You're going to need all of these people to sign deeds. You're going to have to find them. You're going to have to know where they are. And now we're talking about whether you're going to get stuck holding a property a lot longer than you expected to. So the answer, I guess, in summary, is yes, everybody, unless, and I should stop and say this, there, you also may encounter a deed that says that a property is with rights of survivorship. Rights of survivorship means that if one of the people who own the property dies, the others take theirs. So if you have 6 and 1 dies with right of survivorship, then the 5 of them own it, and you no longer need probate. If 2 of them died, then the 4 of them own it. So that's a third evaluation that's another evaluation that has to be made to determine what has to be done on this probate. Was the property of multiple owners in the rights of survivorship? Typically, when somebody dies and they have 5 children, it is not right of survivorship, unless, again, they were sophisticated enough to do that. And that, again, takes somebody doing a deed and recording it to make it from tenants in common to right of survivorship. Harry?
Okay. Can you clarify the length of time the creditors have to make the claim? I thought it was 3 months, but after I just thought I heard you say 2 years.
No. If you give a notice to a creditor, their amount of time is limited to 3 months, or the amount of time it took to publish an ad in the newspaper. If you do neither of these things, then it's 2 years. In other words, it's normally 2 years, that's the statute of limitations, but you could reduce it by part of the probate process, putting an ad in the newspaper, giving them 3 months to file a claim, and or to send an actual notice to the creditor saying you have 3 months. Now, what we usually do in that situation is we publish the notice, and towards the end, we send notice to the creditor, and then it's up to the creditor to see if they can get it done fast enough. If they're even 1 day late, they're barred. They're absolutely out. So it's a matter of, if you want to take a chance and not give notice, then you have to wait 2 years. Harry?
Okay. If there's a living trust, will the trustee have to pay taxes on the estate?
Okay, not on the estate unless the current amount for taxes is $11.5 million, give or take. It's in that range. So chances are, the people you're dealing with, the answer is no. The estate tax in Florida has been done away with. There used to be that they used to get it, but there's no Florida estate tax. And federal, there's no tax on the first $11.5 million. Now they will pay property tax, of course, that doesn't change. And the other question is capital gains. And if there is what is called a step up in basis. If the person bought it in 1970 and paid $20,000 and now it's worth $100,000, if the person who died had sold it, they would have capital gains on $80,000. On the other hand, if you get it as part of probate, as part of an estate, it's now the basis is $100,000 and there's no taxes to pay on it. So those are the different kinds of taxes that are involved in the probate process. So the answer is there's no estate taxes unless it's $11.5 million, and chances are there's no capital gains taxes.
And since there's one other question here about a living trust, there's many questions, but I wanted you to get back into what you're talking about. But
Yes.
This says, can a living trust leave a will for a trustee's distribution?
It's actually the other way around. The living trust can put into it the same things that you would put into a will. So what you do on a living trust is you put all your property, you actually move it into the trust, and then you name who gets it upon your death, just like you would in a will. So just like in a will, you could either be specific and say, I give this property to this one, or you can do it by shares. I give a quarter, a half, or as long as it equals 100%, you can just do it all. Anything you can do in a will, you can do in a trust. So you actually put the provisions for inheritance right in the trust.
Okay, actually, I'm going to squeeze in one more because this will also help us understand where your coverage is. Do these rules and laws vary by state?
That's correct. Florida law, when it comes to probate, you actually have 50 separate laws. They are very similar. In many cases, they're probably exactly the same, but different places have different laws. Florida is a relatively easy state. Other states still make you do probate even if you have a trust, but yes, you would then have to look at the particular state's law to see what you have to do.
What is your area of coverage?
I cover just Florida. I'm only licensed here in Florida.
Okay. You want to continue, or
You have, if there's more questions, I'll.
There are.
Okay.
And I see this sometimes happens a lot, and this is also another thing that makes these situations a little more difficult. But if an heir signed a waiver, give up their rights in the probate, do they still have to sign off on the deed to sell the property?
That's unfortunately a little bit of a difficult question. You have what's legal and you have what title companies say. The legal term for a waiver is actually disclaimer. If a person signs a disclaimer and says, I don't want the property, A title company, because they're being overly protective, may still want them to sign the deed. And that's, the title company that you're using and what their requirements are. But generally, no. Now, keep in mind when a person signs a disclaimer, what they're doing is they're saying that I don't want the property, but they're further saying, treat me as if I had died ahead of time. And that could be significant because if the person died ahead of time and he or she has children, then the children might now be involved because you're treating it like they had died. It is certainly easier not to do a waiver, have the person who doesn't want to be involved sign off on a quitclaim deed and not have to worry about whether or not he has children or not. Disclaimers can be very difficult to use because of the effect is if they had acting as if they had died ahead of time.
Okay, a lot of these questions are very specific. So if you'd like to go on with the presentation, and we'll answer some more questions later.
Okay.
If that's okay with you?
Very good. So now I was talking before about different categories that you need to know about when you look at the property and the title. Another very important category is whether or not the property was the homestead of the person who died. As many of you know, homestead is a very important concept within Florida law. It has various different definitions. And one of those definitions that I'm going to talk about in a minute is the one that helps us get us through these very fast. A homestead is the property in which the decedent resided in, whether or not he had a family, whether or not he was married. If he resided in the property, then it is homestead. If the person had gone to a nursing home, it is still his homestead. It doesn't stop being the homestead because he physically went to a nursing home, which homestead is a state of mind. State of mind saying, if I intended to be my home, then it is your homestead. So if you go to a nursing home, the person is intending not to be their home, but to be something temporary while they get better. Even if there's no possibility of them getting better, it is still their homestead. And homestead, again, has different concepts. One that you all know about, it reduces the amount of property taxes. But in terms of probate, homestead is very important because homestead cannot be attacked by creditors to pay off the debt. In other words, if you own a home and you also owe people money, they have a right to collect their money out of your probate, but not out of your homestead. That is set aside as being protected. One quick story, many of you might have remembered the name Bowie Kuhn. Bowie Kuhn was the commissioner of baseball when I was growing up. And he was also in a firm in which they were all partners. And one of the partners screwed up and got sued for malpractice. And each one owed their share of the lawsuit. And so each one owed over $1 million. So the question was how is Bowie Kuhn going to get out of it when it wasn't really his fault? So what he did was he moved to Florida and he took all of his money and he bought a house, several $1 million. And now that since he moved to Florida, it was his homestead. And then he filed for bankruptcy. The same way in probate, a homestead is protected, it is in bankruptcy also. So he went through the bankruptcy process, wiped out his debts, and then at the end of all of it, he still had a home worth several $1 million, which he then sold and went back to New York. Because he was able to have this protected homestead, his creditors couldn't touch it, and therefore he was able to go on with his life and not owing this debt anymore. Probate is very similar. Probate is protected while you are living and also protected after you die. Creditors can't go ahead and can't attack that and expect to be paid. Now, technically, because of that, The homestead is not part of an estate. It is actually called being outside of the estate. This means that it is not subject to the personal representative, the executor having control over it, but it goes to the heirs or the beneficiaries of the will as long as they're all family members, so that it is not part of the estate and doesn't have to follow the rules. I told you before that there was a creditor's period, and the creditor's period is 3 months in which creditors have a right to file a claim. Well, if the homestead is not part of the estate, then creditors can't go after it. You don't have to wait for the creditor period to be over with in order to complete the transfer of the property. So think about this for a minute. You have a home, no matter how much it is worth, and there are creditors out there, and they can't touch it. It automatically goes to the heirs. Again, who are the heirs? You follow the family tree. It could be first the spouse. It could be children, grandchildren, parents, grandparents, sisters and brothers. And we are able to not wait the 4 months and go ahead and transfer it. If there is a will, then the will says who is going to be the beneficiaries. And this is very important. If the beneficiaries are anybody other than family members, then the property loses its homestead status and does have to go through probate. So it's important to look at the will and see if it's being left to only family members. And why is this important? Again, is because we do not have to go through the waiting periods. And if we don't have to go through a waiting period, we don't have as much expense in doing the probate. And that's how we're able to do probate in a couple of weeks. What we do is we file, I mentioned before, something called a summary administration. And why can we file a summary administration? Because if the home is the only property, then there's actually no assets in the estate because the home is not considered part of the probate. Or again, if the person was deceased more than 2 years. But usually the one we deal with is the fact that there's no assets. If there are other assets that push us over 75, then we have a problem. So in other words, if you come to me with a property that was the decedent, the person who dies, homestead, we can knock this off in a couple of weeks. And the first step is to file a petition for summary administration that basically tells the judge, open up the court file because I have a homestead property. The second thing we do is we file a petition to determine homestead. This is for the judge to say, yes, this is homestead. And because it is homestead, this is who it goes to. Once we get that order, you can close. So let me say that again. Within about 2-3 weeks, we can get an order determining homestead, declaring the property to be the homestead. And therefore, the people who are owners of it are named, and they can close the property immediately. They do not have to wait for anything. So to do this process, we need a bunch of things. I've already told you we have 2 petitions that I have to draft. One is a petition for summary administration telling the judge what the story is of the file. A petition for homestead telling the judge the property was the decedent's homestead and therefore declare it. If the person was deceased for less than 2 years, I will need a paid funeral bill showing that the property, that the person's funeral has been paid. The court will not proceed ahead unless they get that paid funeral bill. If there were bills from the last illness, the person died after a long illness, not something that was abrupt, but if there were last bills, I would need to show the court that the last bills were paid. Usually the funeral bill is enough. Now, in Broward County and in Dade County, for example, and other counties within Florida, we need to do an affidavit of heirs. An affidavit of heirs is done when there is no will. So when there is a will, the judge knows who the beneficiaries are. But when there is no will, this affidavit of heirs follows again the family tree and tells the judge who is entitled to the property based on the Florida statute. And so you list whether there was a spouse, whether there was a spouse, whether they were divorced or died, who the children were, who brothers and sisters were, who parents were, and this is filed along with it. In Broward County, we need to file what's called an affidavit of criminal history. While there's nothing that a judge can do to stop a person being entitled to property, even if he was convicted of a felony, in Broward County, they want to know who they're dealing with. So they ask for an affidavit to say whether or not the person has been convicted of a crime, and if so, what the crime was. Again, they can't stop them from getting the property, but they want to know. In Dade County, for example, we need to file proof that this was the person's homestead. And in Dade County, they do it with another document, which is a disinterested person affidavit. It is somebody who's not getting the property, who can say that the person actually lived in the property. It's something that I make up and send to you to be filled out. It's anybody other than the person who's getting the property. We also need a utility bill showing that the utilities on the property were in the name of the person who died. It could be any kind of utility, water, electric, whatever, but show that he was paying the bills. And finally, we get a tax bill, which I get off the Dade County website, showing that the property owner listed in Dade County is the person. Once we get all these filed, we file all this electronically, so it's very quick. In other words, we do it online, and then we send the death certificate in. They will not proceed until the original death certificate has been filed. Usually it takes 2 or 3 days to get up on their docket sheets, depending on how mail is doing that day. And once all these things are filed, we can send an order to the judge, who will sign off on the summary administration order and the order of homestead, saying that the property was the person's homestead, and it goes to the following heirs. So this is how we are going to be able to accomplish what normally takes 4 or 5 months in 2 to 3 weeks. We are able to get you an order that the title company can then record and continue the chain of title from link to link to link in this particular case. I think I'll stop now and see if there's any questions regarding the particular homestead property that we're able to resolve. Harry? Harry?
Sorry about that. Just
Oh,
coming
okay.
back in. Okay, that's amazing information. I know even though I know quite a bit, my head is definitely buzzing quite a bit. Let's see, a couple others. Oh, here's a good one. What determines the value of property if it's under $75,000?
If it's real estate, it's going to be the fair market value. If it's anything else, like it's bank accounts or brokerage accounts, it's whatever on the accounts. So we're going to add up everything and see if we go over 75,000. Now, I've had properties that were just exactly 75,000, and the problem is if you then sell it for 90,000, you've said that the 75 was incorrect. So you got to be careful and make sure that we can go ahead with those values. Now, let me say this. I mentioned that we're talking about homestead property. Let's say you're buying a property for under 75. You could do summary administration on that. And again, it'll take 2 or 3 weeks. In other words, summary administration, again, under 75,000, dead more than 2 years. So if the person has been dead for more than 2 years, no matter how much the value is, I can get it done in 2 or 3 weeks under summary administration. If it's less than 75,000, again, I can get it done 2 or 3 weeks under summary administration. I don't know if I made that clear. The point is that since creditors are barred after 2 years, then we don't have to go through all the publication and notice requirements. And under 75,000, the court says, if the creditor wants to come back later, we'll deal with it later.
Right, I got a question here, Fred, that
Sure.
I did that message. Like, I'm gonna like, I know we're kind of diving pretty deep in. I'm gonna bring it back. I call it a niche proof, meaning I'm gonna dumb it down a little bit. And so when you speak to a homeowner, right, and you know somebody passed, how do you know? Like, we get this all the time. Oh yeah, I think it went through probate, or it's in homestead. So if you're a newbie investor, right, or how do you even know if you're looking on public records? If it's in probate, has it been filed? Is there some background work? Because I don't want to say, sellers are, I'm not going to say what I want to say, but sometimes they don't tell you the truth on that.
Well,
So what would some of the
let's
best
assume,
practices? Yeah.
rather than saying that they don't tell you the truth, that they're not sophisticated and don't understand the proof.
So you should run for office. So
Actually, I did in Hollywood 20 years ago. But anyway, people who are not sophisticated in law and real estate do not realize that if they were left a property, either because their parent died or because they were left it in a will, that it has to go through probate. Very often they think automatically it's theirs if it's been said that it's theirs, and they don't do anything. You, of course, can't buy it from this person unless the procedure is done. The good news is it might be more than 2 years, so it might be an easy process, even if it's not a homestead. But the point is that they probably don't know that they needed to do probate, and the property is just, or they knew and they didn't want to pay for it. So they said, okay, I'm not selling it, I'll leave it go. And now you want to buy it, but you can't because the probate is in the way. So the simple answer is that you can go online and find out. If you go to the property appraiser's website and it has never been transferred to somebody, it will say the name of the original owner with the words estate of in front of it. And that's going to tell you that nobody's ever transferred it. The property appraiser still considers it within the estate. By the way, keep in mind that once a person dies, the homestead exemption is lost, and the estate tax, the property taxes will go up. So if you're evaluating the property in terms of how much the property taxes are, be aware that they're artificially high because of the homestead exemption being lost. So that upon a new homeowner moving into the property, those taxes are going to go back down again. The second way that you can tell is by, how on the property appraiser site, you can look at the deeds.
Mm-hmm.
You can look at deeds. So you can look at the last deed that was there and see who it went to. If there's nothing, if the last deed is still the name of the person who had died, then no probate has been done. Because the probate will be shown just like deeds. You won't be able to see the probate because probate files are confidential, but on the recorder's website, you can't look at probate deeds and things, but you can. If there is nothing listed for probate there, then you know it's in probate. The other thing is you can go to the clerk of the court of either Broward County, Dade County, whatever county you're dealing with, and look for court records. You'll be able to go to probate, put in the name of the deceased, and see if a probate comes up. So it would be the estate of, and if you can go and look at it, you won't be able to look at the documents, but you'll be able to look at the docket sheet if you find one to see what's done. Sometimes probate is started and never finished,
Yep.
And then it's still in the name of the estate. So again, I'm happy to do that for clients who want me to do it for them, to let them know what the state is so that they can go ahead and decide whether they should go ahead and buy the properties or not.
Yeah, and so the second part of that question, let's say, my wife and I, we have a homestead property, I pass away, and we have an investment property too. So I get this question too also, does it automatically transfer? Is there probate needed if we're married? Like what would be something on that nature, or if I had multiple properties, let's use that.
If husband and wives own property together, it is automatically survivorship, whether the deed says so or not. So when the first spouse to die, there is no need for probate. It automatically transfers to the surviving spouse. It's only when the second one of you goes, that you'll then be required to do probate. Now, if you put it into a trust or done one of the other things, then you could avoid all that. But probate, again, probate is not required when the first of two spouses dies.
Awesome. So I'm going to let you kind of get back. I know you had a lot more information, and then what we'll do is we're gonna do like one of those speed rounds of questions.
Sure.
Where on that end, because I know it's so funny. The time always goes by so quick. With you've given us so much information. We only have about 20 minutes or so. So I know you had some other points that you wanted to hit, and then we'll come back to you. And you know what this means automatically, Fred. We're gonna have you come back.
Not a problem. There are
Awesome.
other title issues we can talk about having nothing to do with probate or doing with probate. So I gave you a list before of the documents that I'm going to need. And with that, I want to be able to tell you what you can do to help me to get this done fast. If you're one of my clients, I will provide you with forms that you can give to the family immediately so they can start filling them out. Because when I say 2 to 3 weeks, it's 2 to 3 weeks when I get all the forms in. So one of those forms again is the affidavit of heirs. To fill it in, it is not a difficult form. It's really names, whether the person is still alive, their address, and this is the way again for the court to know it. So one blank form that we need from you is the affidavit of heirs. In Broward County, we need the affidavit of criminal history. And this is if there is no criminal history, the person was never convicted. And that's important. Arrested is not convicted. Finding of no contest is not convicted. If a person has been convicted or not convicted, they're going to initial saying they were, they weren't, and give the information if they were. We need a death certificate. A death certificate has to be an original. Those are the blue ones here in Florida. If they don't still have an original death certificate and person died within the last 10 years, I can get it here in Broward County by just stopping by Broward County Board of Health. I happen to have one that's a few blocks from my home and is very convenient to do on my way into the office. So if you have one, besides it saving the $15, it saves time and being able to go ahead and file it. Excuse me. So we need an original death certificate. When the person has been deceased less than 2 years, we're going to need a bill showing that the funeral parlor has been paid. Now, I don't need an original. You can have them email it to me, or the funeral parlor can email it to me. It just has to be attached to the petition. Again, it has to show that there is a zero balance. If the client doesn't have it, don't worry about it. On the death certificate, there is always the name of the funeral parlor, and I can then contact them and get a copy of for myself. So, and usually funeral parlors are cooperative, although sometimes they'll want to hear from the family of the deceased for permission to give out the bill, but normally they'll send it to me when I let them know that I'm the attorney handling the probate, and we have to attach that. So now I will need the names of the heirs or the beneficiaries, if there are siblings, if it's cousins or whatever it is. I will need all the names and all of the addresses. So because all of them have to be on the petition. All of them will have to sign the petition, or if they're refusing to sign the petition, I can send them a notice, and then they have 20 days to respond. So as you can see, if I can't get the cooperation of all the heirs or all the beneficiaries, then we're not going to be able to finish in 3 weeks. So, which brings us to the next topic, which are properties that you may wish to avoid. And that was one of those categories. Properties in which there are several heirs, whether it's children and grandchildren, great-grandchildren, all depending on who's died since the decedent died, or who died before the decedent died, anybody who in the chain that has died. If there are a lot of them, it can be done, don't get me wrong, but it's going to be a long process. you've heard the expression like herding cats. You basically have to get everybody to sign off now on the probate, and you're going to have people sign the deeds. Not the there's no executor, so everybody has to sign the deeds. So if you see that you have, I've had them with I had one with 21 different heirs, and they had to go around and get all these people to sign off on both. So you're now talking again, can you afford to wait till all of this is done? So that's number one. Number two is the situation where the family doesn't get along. They don't know each other. One of them wants to stay living in the house and one of them wants to sell it. All these are things that without cooperation, this process is going to get lengthened. It's going to be to your detriment as the property has to be carried. The point is that I have had many cases in which somebody didn't want to sign, and it is just not worthwhile for you to get involved in that kind of deal. Unfortunately, the next one is one that you won't be able to find out about probably until title work is done. But if anybody who is going to inherit this property has a criminal background, has judgments against them from lawsuits, child support issues, anything like that, you may have a very difficult time trying to be able to sell this property. Why? Because those judgments are going to vest against these heirs. And once they vest, they're going to have to be paid off. And is the amount due larger than the amount of money that they're going to get? Is it child support in which the person is refusing to pay it and doesn't want? Or will he or she stop cooperating when they find out that they're not going to get any money because they have to pay off judgments? So you need to get an idea of who you are dealing with. If it's one person, great. It's easy to find all this information out. Again, if it's a lot of people, then you need to know about each one. I had one in which there was 5 children and there was child support payments due. And he didn't want to make the payment. And eventually the deal fell through because he wouldn't let his money be used to pay the child support. So don't waste your time on these properties. So what you can do to help this out as being the investor is the first one is gathering all the information that we've talked about today. 2 is to get the documents, and I can give you blank ones ahead of time so that you can get them to sign it right away. And 3, to be able to know where your heirs are and what's going to have to be done to close these properties. It is great when it's nice and simple, of course. It's not so great when you have to sit and wait. Please feel free, when you're my client, to be able to call me at any time and ask the question ahead of time. I'd rather you ask the question and the deal fall through than we go 3, 4, 5 weeks and then find out it's going to fall through. It's not worth your time. It's not worth your money. We need to go ahead and do that. And with that, again, we'll stop for questions.
Yeah, so I gotta, us living here in South Florida, sometimes unfortunately the heirs are out of the country.
Mm-hmm.
So obviously the deed has to be signed, like what you were saying. Have you dealt with it, or do you want to explain how to? I know these are extra steps because I've done it. What you would, what advice would you give to our investors if you found out, hey, one heir lives in wherever, Colombia? On that portion, what have you guys done?
There actually is several ways of trying to take care of that problem. The first one is just having the person sign it. Now, when I say just having the person sign it, if there is somebody who takes oaths, we call them notary publics here in Florida, but they're very often called commissioner of oaths or something else in the foreign country. If it's somebody who is legally authorized to take oaths, they can have they can sign it before that person, get the originals back to me or to the title company. In probate, I usually don't need oaths unless it's Broward County and I have those affidavits to deal with, the criminal affidavits. But otherwise, it could be the deeds when it's time to close. So the first one is going to somebody who is authorized by law to take oaths. The second one is they can go to the U.S. consulate in that country. That sometimes is easier and very often is not. The reason why it's often not is usually you have to make an appointment, and depending on what the consulate is, the appointment could be a couple of days or a couple of weeks. But every consulate has an officer who is able to take oaths, and that person will then put their stamp on it, and the document comes back, and we're able to close. There is now a new way to do it over the last year or two, which has to do with doing it online. If the person is a U.S. citizen and their identification can be verified, and there is certain ways to verify it, it could actually be done online, where the person can take the oath here in the United States, here in Florida, and they can sign it on camera wherever they are. It is a great innovation that was done. It is, they are mostly finished with working out the kinks. But if there is a person who is a U.S. citizen or resident who happens to be overseas, that is a way of getting it done.
Yep, I've actually done both. So yes, the consulate, in general, I agree with you. It was like a 60-day wait for an appointment,
depending on where it is, right?
Yep. So that took some time. It was fine. And when you were talking about the 21, so one of my first probates, gosh, like in 2007 or 8, I had 14 heirs in Jamaica, all over the place. It took 2.5 years. So yes, to get everyone on board, to finally agree.
Herding cats.
Yep, exactly. So that's definitely one of those things that you're bringing up some great points. I'm like kind of laughing because I've lived through a lot of those. You've already talked about.
Well,
by
for
accident.
newbies, I mean, you could probably tell them how much it costs in terms of time and money to get these things resolved, and then depending on your margin, whether or not it's worthwhile to continue with that deal.
Absolutely, absolutely. Harry, I know you got some. Did you have a couple questions you want to add on?
Yeah, well, I'll tell you, I had one also where we had the heirs were in Barbados. It was challenging and started to get a little expensive. Some more questions. Oh my goodness, there's a few. There's one here. Can a realtor list it for sale? When can the realtor list it for sale? So I'll let you answer that one first, and we'll go. So when can a realtor list a probate for sale?
I would list it immediately. Here's another legal technicality. When it's a homestead property, the heirs own the property immediately when the person died. It's not of record anywhere, nobody knows about it, but technically they own the property, and therefore they have a right to list it immediately.
Okay. Transferring a property to a living trust trigger having to pay tax stamps on the deed?
No.
Okay.
The answer is no. There's no consideration transferring it into the trust. There may be in other states, I don't know, but here in Florida, there is not considered consideration.
Fred, just had a question on that second half. Even if it has a mortgage on it?
Even if it has a mortgage on it.
Oh, see, learned something new there. Okay, cool.
If probate is started and full administration is done after many, many years, it is still not completed, can it be converted to a summary administration? And if so, is there a benefit to doing that?
The answer is that probate in and of itself does not transfer the property. Something has to be done to transfer the property. It could be the personal representative, what is commonly known as the executor, could do a certificate transferring it to the heirs or beneficiaries. It could be a court order transferring it to beneficiaries, but something actually has to be done. If a probate was opened and never completed, then the act of completing is fairly simple. You reopen the court file if it's already been closed, and then you bring it to the judge and he signs off on the orders. If it's gone past the period of time for the creditors, to the 2 years, then you probably don't even need to change it to summary. You can just knock it off in the full administration.
Okay. This one's a little more specific. I'm an executor of a trust. I'm also a realtor. My cousin wants me to sell her house as part of the trust. Do I need a document like a listing agreement?
Well, listing agreements protect realtors, not the sellers. So the answer is yes. You're not the executive of a trust, just technically you are a trustee of a trust. As trustee, you have the authority in probably 99.9% of all trusts to sell property. So you have the authority to go ahead and sell it. And then as trustee, you can sign the listing agreement hiring the realtor, whoever it's going to be. And obviously there's the disclosures of realtors selling property that they have control over.
Okay, this one's loaded because I know the answer, quick answer is no, but obviously the situation is not spelled out here enough to really make that decision. If the mother of 3 children passed away and 2 children want to sell the house and 1 child doesn't want to sell, is there anything you can do? I don't think we have enough information.
Well, actually, probably can. The problem with when properties are owned by multiple people is exactly what you're saying, is that you may not have full agreement. You have to have full agreement to sell the property. So once you move the property into the name of the heirs or the beneficiaries, and then 2 want to sell and 1 doesn't, you then have to move over to civil court and do what is called a partition action. A partition action is when multiple owners can't agree on what to do with the property. It could either be sold on the courthouse steps, like a foreclosure, in which case everybody's going to lose because the amount of money they're going to get is low. Or they could ask the judge to name somebody to sell it like a regular transaction and sell it with a listing and all of that. Unfortunately, partition actions take some time, depending on if there's an issue about who is entitled to what money after the sale is, and it costs money. So again, everybody's a loser because now you're gonna have to pay attorney's fees to do the partition action. So the problem is that that third person is probably living in the property and they don't want to move because they've got a free house. So free place to live in. So the only thing that you can do at that time is the partition action.
Okay, is a quiet title action a viable solution to handling titles with multiple heirs that you can make contact with?
Yes, well, yes and no, because they are the heirs who you can't get in contact with, they're still entitled to their portion of the property. Florida law says that if you've got money left over for an heir that can't be found, it gets put in the court registry and eventually to unclaimed property, where if that heir ever shows up, he can go ahead and claim his money. So you can resolve the issue, but don't think that the person you're dealing with is going to get that person's share. It's going to actually go to Florida to be held.
Okay. Homestead. The owner's family can sell the homestead separate of probate and other assets. Correct?
Yes, that's correct. The probate may have to be done as a full administration, depending what other assets they have, but homestead is separate from everything else.
Okay, what if there is no will and there is no living family members? Can investors still purchase the property? If yes, then how?
That's very difficult. That one, if you have no family, I mean, everybody has family somewhere, as far out as the family tree may go. I mean, I remember when I was bar mitzvahed and my father was inviting 13th cousins, but the point is that there is always somebody out there. The last heir is the state of Florida. If no heirs can be found, the state of Florida is entitled to the money. So it's something you probably, if you have a client involved, you probably want to avoid. If it is a non-family member who says, I live next door and he's always said it was going to be mine. If you're a non-family member and there's no will, it ain't yours. There's no way for you to get it through probate if you are a non-family member and there's no will. So don't believe somebody who says, oh, it's mine. He always said it was mine.
Yeah, I've had a couple where we've exhausted all avenues and could not find anybody, and reluctantly, kicking and screaming, had to let it go.
Yep.
Okay, what's the best ways to handle all of the forms being signed off if there are heirs in many states?
The answer is you just have to.
Just do it one by one, right?
Yep, exactly.
Okay. Can a creditor attack the money from a sale of a homestead? I think we covered that
The
earlier.
answer is absolutely not.
Okay. Do the forms all have to be witnessed?
Oh,
and
let me
notarized? Oh.
correct what I just said. They can attack the money from the homestead until it goes to the heir. Once the heir, the creditor of the estate can't. A creditor of the person getting the money can. In other words, once they get the money, it is no longer part of the estate. If that person owes money, a creditor of that person can go after the money. But the homestead is an absolute, so the decedent's heirs can never go after them.
Good point. Very good point. Do the forms all have to be witnessed and notarized?
The affidavits do, not the probate documents. The affidavit of heirs and the affidavit of criminal history both need to be notarized.
Can we find the probate cases online?
Yes, the probate cases are on the clerk of the court for whatever county you're in, Broward, Palm Beach, Dade, and then go to go to records and go to case records. And then when you go in, you're able to put in the name of the decedent, of the person who died, and all the cases against him, including probates, will pop up.
And you have to register to actually see the
Documents, right?
Okay. Someone's asking to clarify Nisha's last question. Does the property automatically transfer to the surviving spouse if the property is titled under an entity like an LLC?
If the property is in an LLC, it is not part of the probate. It is what goes into the probate is the LLC. So it's then no longer an issue of homestead because it is the LLC that's in the probate. And then the regular rules of probate kick in.
Okay. A couple more. If one of the owner's children passes away and has kids, do the kids need guardianship if they are underage?
Absolutely. And the reason for this is because if they're underage, they can't sign deeds to transfer the property. Guardianship, for those who don't know, again, is a process whereby somebody who is incapacitated is protected by the court. One of the forms of incapacity is incapacity of minority. In other words, the person is still a minor. In Florida, minority is 18 years old. So if a person gets it who is under 18, and I've had many of these cases, they can't transfer the property unless a guardian is appointed, usually the parents, usually the other parents, and that guardian can then sign the deed or whatever documents. The money from the sale will go into a guardianship account and will be protected until the child reaches 18, with the court supervising and asking for accountings and all that to see what happened to the money. It is unfortunate that, again, the sophistication of the person who died of leaving it in that situation. Estate planning is to avoid these problems coming up later.
To throw a little wrench in the works on that
Good
question, what if that child passed away predeceased the parent? Do their kids still have rights?
Yes, because it's still the family tree and it still descends down the family tree.
Okay, excellent. Okay, and the last question on this list, believe it or not, we've answered 26 of them. Oh, well, someone just popped another one in there. So 2 heirs are wanting to sell, and one of them is the personal representative, but we need the third heir to still consent to an appointment of the personal representative. So there's 3 heirs, I guess. They have health issues. Is there a way around this? 2 heirs.
First of all, let me clarify though. When the way we were talking about transferring the property is without a personal representative. The summary administration homestead method does not have a personal representative appointed. If you have to go to a full administration, if a majority picks a personal representative, then the personal representative, if it's in a will, then obviously the person named in the will. If it's intestate, no will, then it's the person who a majority of the heirs pick. Again, if it's homestead, it's going to have to be signed off by all of the heirs. So again, you're in the same situation. You're going to need all of them to sign off eventually.
Okay. And yes, they're going to call me a liar here because of the more questions popping up. On the clerk of the court website, is there a way to specify or identify probates that died and left the property to someone without going through all the different probate cases?
No. The only way you have it is when somebody brought a probate case. Otherwise, they wouldn't be on the clerk's site.
Okay, I know I
Yeah.
like to find my probate cases off market before it gets to probate. Makes it a little easier.
Absolutely.
But thank you, Fred. This was
Yeah, Fred, way to crush that in 90 minutes. First of all, I mean, that was a ton of great information. One of the things is I know people are asking about fees on that end. It's going to be depending. The easiest thing I'm going to tell you guys is Fred is working hard on cases. Please do not reach out to him just if you have questions, meaning you're not really working on a deal. Otherwise, Fred will no longer do any webinars for us and give out his information on that end of it. Because what you have to understand is we have close to almost 100 people on this webinar. And I know you guys have a lot of good questions in general. I just can't, again, Fred's been more than gracious enough to even do this webinar. So again, he's fantastic. Use him for services, but we cannot have you go out to our experts and say, hey, what about this or what about that on that situation? If you're working on a case, absolutely, please go ahead and move forward. I just can't have you guys taking advantage of that. What I can tell you, I don't know, Fred, if you want to, you do probate, you do regular title services, estate planning, and did I miss something else?
We do estate planning and guardianship. So if you have that situation where there's a minor who's inherited, we do estate planning, real estate. We do everything a title company does. As a matter of fact, that's where you'll get to meet my wife, who usually does the real estate. While I do estate planning, which is wills and trusts. I am happy to take on more clients. As you can see, we move very quickly in doing all of this. The point is I know it's costing you money if I'm not right on it. So the minute I get something in, it goes right to the court. And the minute I get the death certificate, it goes right to the court. So I'm happy again for clients to answer the question, is this a viable property for me? Or am I going to get caught up in a probate process?
Yeah, and today is really not about you guys becoming probate experts. I am far from being a probate expert. I've done deals for years and I learned a bunch of stuff today. The idea is having a power team. This is why Fred's part of our team. You're not going to be, after watching a 90-minute webinar, a probate expert. So today was just some basic ideas of some of the basic concepts, the questions, and to be ready for it. So I want to, obviously thank Fred for that. I know we have a winner, Alexa, also. Who's the person that got paid to hang out with us today, paid to listen to Fred talk?
Yes, you read my mind. So I do have a winner for the 1-year membership to BPM RIA. Our winner is Tanya B. Congratulations, Tanya. I am so happy for you. I will send you an email with your membership details, and thank you for coming to our webinar today. And thank you to everyone else who opted into the raffle. We had a lot of you, so next time, there will always be an opportunity.
Well, tomorrow will be an opportunity. I mean,
Oh
I
my
feel like
gosh.
Oprah. We're just giving away memberships.
Oh.
Membership for you and a membership for you and on that end of it. So make sure you guys check us out. So one of the things is we constantly get these things. The replay will be up in 48 hours. So make sure you subscribe to our YouTube channel. Fred went over a ton of information. That's the New Yorker in him. He just banged it all out and gave us a ton of information. I'll probably watch the replay because I probably missed some things like, whoa, on that end of it. So make sure you subscribe. More importantly, when Alexa sends you the link, make sure you give us a 5-star Google review, especially, Fred, because otherwise he's not going to come back. If he doesn't feel any love, he's not going to come back. And what we might do is, I'm not going to put him on the spot yet, but maybe we'll have him come back and estate planning or another topic for another 90 minutes.
That's what I was going to suggest. If you want to ask the membership what they would like to hear about in the legal area, if I can't do it, I'll find somebody who can.
Okay, yeah. So I think that's always important. I want to thank Mr. Harry Diamond for bringing Fred on, asking all those tough questions, and again, we've made a lot of money in probates. If this is not part of your strategy or part of your power team, great, because that means it's more deals for Harry, myself, and our students. No, I'm kidding. Like, you want to be able to go out there. There's, again, we're very committed into education here at BPM RIA. We're also, doing deals, and we want to be able to change neighborhoods. And it's going to take people like us to really make an impact on neighborhoods. Again, we want to thank Fred. I'll see you guys tomorrow on our WIN workshop. I don't know, maybe you'll just tune in to see what kind of music Alexa plays on that end of it. Maybe she's part-time DJing. I don't know, music conference is coming up. Who knows what she's doing out there. So thank you guys very much. Thank you, Fred. Thank you, Harry. Thanks, Alexa. We'll see you guys tomorrow.
Thank you,
Thanks, Fred.
Thank you, guys. Have a great day. See you tomorrow.